Next matter is before us is Teodecki versus Litchfield Township. Take a moment to get settled. You may proceed when you're ready.
Thank you, Your Honor.
As you know, you will reserve up to 5 minutes.
And once again, Your Honor, I will reserve 3 minutes for rebuttal. Once again, I'm here. I represent Joyce Teodecki, the appellant. My name is Teodecki, and the appellee is the same defendant appellant as was in the last particular case, Litchfield Township. We've raised 2 assignments of error in this case. First assignment of error is that the trial court erred in granting summary judgment in favor of the appellant. The second assignment of error is that the trial court erred in granting a motion for a protective order to the appellant and a motion to quash to the Medina County Prosecutor's Office in this case. The facts are long and convoluted, however, I will try to summarize them. Basically, Ms. Teodecki is the former fire chief in Litchfield Township, and Ms. Teodecki was the subject of an investigation called by the township trustees into her activities as fire chief pursuant to revised code section 505.38. What that section does is that gives township trustees the ability to call an independent investigator to look into the activities of a fire department, an officer in the fire department, or the chief himself, in which they did. They appointed this independent investigator and hired the independent investigator to look into Ms. Teodecki's activities. What happened here is that there was the independent investigator came up with an investigation report. That report was not officially presented to either Ms. Teodecki or the township trustees. However, they had a township meeting. Negotiations were started to determine what should be done with this. Should there be a trial based upon the investigation report? Should the trustees determine that there should not be a trial? What happened was that they entered into an agreement, and in this agreement, Ms. Teodecki agreed that she would resign as fire chief of Litchfield Township, and basically, in return, that as no one had actually seen the investigation report at that time, that the prosecutor and the investigator would keep the investigation report confidential in return for her resignation. Later, a meeting was called a few months later, whereby the trustees, let me back up here. That particular agreement was memorialized in a resolution, Litchfield Resolution 2211, where in that resolution the language with regard to the confidentiality of this agreement was placed in the resolution, along with the acceptance of Ms. Teodecki's resignation, and also her actual resignation letter was referred to that resolution.
And so it was indicated that the report was confidential.
It was indicated that the report was...
In the resolution and in the minutes of the meeting.
That's correct. Now, what occurred later is that the trustees called a special meeting a few months later, voted to revoke Resolution 2211 to an extent, and only to the extent that they revoked the confidentiality clause, which would keep the investigation report confidential with the prosecutor and the investigator, and at that point released the report to the public. So we have...
If I may ask, who was required to keep it confidential?
In the document itself, it said that the report will be, in fact, I'll read it to you. The results of the investigation shall be kept confidential between the Medina County Prosecutor's Office and the investigator.
So the investigator couldn't disclose that, neither could the prosecutor.
That's correct. And the reason that it was worded in that manner is that at that point, because under 50538, the trustees are the triers of fact in a trial for misfeasance of a fire chief. So they had not seen the report, or at least Ms. Teodecki was advised that they had not seen the report at that point. So the trustees could not having it in their possession, could actually not say that we are going to keep it confidential because they didn't have it. Ms. Teodecki had not seen the report either at that point. And that goes to one of our issues. One of our issues is obviously that Litchfield breached the contract by releasing the report to the public. One of the issues is that, and what Litchfield claims is that Litchfield is not a party to this agreement, but only the prosecutor's office and the investigator were the parties to this agreement to keep it confidential. Well, the issue there is this. The investigator is most definitely a hired agent of the township. In addition, the prosecutor's office acted as counsel to Litchfield Township at the time that the agreement was negotiated. In fact, the prosecutor's office drafted Resolution 2211. The prosecutor's office even drafted Ms. Teodecki's resignation letter. In other words, they were acting as an agent of Litchfield Township in this particular agreement. Now, as we probably all can remember from practice, many times clients will ask their attorneys to hold something in escrow or hold something confidential as part of an agreement, or attorneys will make those types of agreements. The prosecutor's office was not independent of Litchfield Township with regard to this particular agreement. As part of that, Litchfield Township determined that they were going to release this to the public. They went to their attorney and said, please, can we have this ability to release the results to the public? Can you give us what you have, what you've been holding for us as part of this agreement? And as a result, the prosecutor said, well, you are my client. If that's what you want, this is what you will get. Here it is. The prosecutor is not part of this agreement. The prosecutor does not have there has to be consideration for a contract. The prosecutor had no consideration to give other than to act as an agent for the party that did have consideration, basically, to give the confidentiality clause.
The prosecutor was an independent entity with, and I think this is what the trial court struggled with as a public officer. Could the prosecutor be bound by the agreement between the trustees and your client?
I think that's kind of an issue that is, and the answer to the question, I believe, Your Honor, is no, to some extent. As counsel, as the attorney for Litchfield Township, I believe that they can actually say, okay, if you want this to be confidential, as my client, I am going to assist you in making sure that that happens. What the township can't do is go into the powers of the prosecutor, meaning the power to indict, the power to bring charges. But none of that is present in this particular case. In other words, if this particular report said that Ms. Teodecki committed felonies, and the prosecutor decided, regardless of this agreement, I am going to prosecute Ms. Teodecki, there is nothing, we wouldn't be arguing about that. Because the prosecutor has that independent power through its office. However, none of that was done. Ms. Teodecki was not prosecuted. So basically, the power of the prosecutor to represent townships under Ohio law means that that prosecutor is their attorney, as any private attorney would be, as any law director would be to a city or solicitor to a village. And in that, they, as the attorney, acted as their agent. This is not an issue with regard to whether or not the township could tie the hands of the prosecutor in this matter. They did not. They asked the prosecutor to act as their agent in this matter. Now, there are issues raised with regard to the contract. And as I said, one is about the prosecutor and the investigator. The other is whether this was an invalid contract modification. Now, that particular issue, I think, is I don't know where that comes from, because in Resolution 2211, there was this confidentiality clause was interdelineated. As I said, the prosecutor came to the meeting with these documents prepared. So this was interdelineated into Resolution 2211 by Ms. Teodecki's request. However, the entire document was approved officially by the trustees at the meeting with a unanimous vote. I don't know how a modification could have occurred here. The fourth issue,
Well, let me back up, because I want to make sure I understand, because my understanding was that the agreement was typed, was prepared, but then there was, the confidentiality part was handwritten.
That's correct.
Are we going to find that it was initial? The handwriting?
No, I believe that it was not initial.
Okay.
But as I said, the documents, the resignation letter and the resolution were prepared prior to the negotiations. In the negotiations, the parties agreed that this confidentiality clause would go into the resolution. Both documents refer to the other, and I believe would be considered one contract. Both parties signed the agreements through those two documents. And in fact, the township trustees approved the resolution in their open meeting through their official approval. They voted in favor of it unanimously.
And you are at your 3 minutes. You may, of course, continue as you wish.
Your Honor, I'll reserve it this time. Thank you.
Good morning, Your Honors. May it please the Court, Edward Patton on behalf of Litchfield Township and the Litchfield Township trustees. Your Honor, getting to the nub of the issue here, appellant is focused on this confidentiality clause, which was part of a resolution, was handwritten into a resolution. What appellants failed to inform the Court, but is amply demonstrated in the record, is that the appellant herself is the one who disclosed portions of the investigation through an open letter that she mailed to the community and that she distributed to the community. She indicated certain things in the report in this open letter, which essentially compelled the trustees to act as to at least let the contents of the report out. Your Honor, under Ohio law, if we believe the appellant's case that and I'm not asserting that the confidentiality was part and parcel of the separation agreement, but if we take the appellant's position that it is, Ohio law allows a non-breaching party to a contract to excuse for complying with the conditions of the contract when the person for whose benefit the condition operates has materially breached the contract. Now here we have the appellant, a public official, a firefighter, the chief of the fire department, who disclosed the contents of these reports in an open letter to the community. I think the township trustees then were compelled to at least set the record straight to allow the public for administration of the township to know what actually had occurred.
Well, that, I understand the sentiment, particularly in light of some of the references in the letter. But if we're looking at this from a legal perspective, what was the breach?
Well, technically, there was no breach because it was an agreement between the prosecutor and the investigator. It was contained within the body of the resolution, which was subsequently modified lawfully on the record by the trustees when they had the subsequent resolution which removed that. That's after being informed through the fiscal officer of the township from the prosecutor's office that the appellant had apparently began disclosing the information contained within the report through these open letters. Therefore, any issue with confidentiality as to who the target of the investigation was or what may have or may not have occurred has been weighed by her, and they feel free to do with it as you please. And so the township then enacted the enabling legislation which allowed them to at least disclose the contents of that report. Your Honor, there is no evidence that on the record that the confidentiality clause, which was not signed off by the appellant, was part of the offer, acceptance and consideration for her discharge and subsequent consulting arrangement that was arranged with the city that kept her on as a consultant through the end of 2011. That is the only document that was signed off by Ms. Teodecki and Mrs. Teodecki, the former fire chief. And that document itself is also supported in that Ms. Teodecki stated in her depositions, which are part of the record, that the confidentiality clause did not form a basis of her arriving at her decision to retire and then stay on as a consultant through the end of 2011. I think there are at least 2 or 3 citations in the record that was not a fundamental or the linchpin or the underlying of this agreement for her to leave the fire department and stay on as a consultant. So it was not part of the contract formation. The contract between the Township trustees and Ms. Teodecki was the fact that she was going to resign as of July 5th, or straight to July 25th, 2011, and be retained as a consultant through 2011 at a rate of, I think, $700 per month. That was the contract between the parties, signed off by the parties, and in fact supported by the evidence in Ms. Teodecki's own testimony that the confidentiality clause had nothing to do with her decision whether or not to remain on as chief or not. I don't think that the appellant raised or disputes in the brief that she was a public official. I think it's very clear that a fire chief, much like a police chief or a mayor or a township trustee, is a public official. Therefore, on any of the defamation claims that she alleges, she must prove that the township trustees acted with actual malice. And I submit to this court there is a complete lack of any evidence that anything was done with actual malice towards Mrs. Teodecki. Regarding the issue of the subpoenas and the quashing of the subpoenas that was granted by the trial court that counsel had argued this morning, the standard that's to be applied by this court is the abuse of discretion standard. The trial court acted arbitrarily, unreasonable, or unconscionable. If you look at the subpoena request that was issued by Mrs. Teodecki to the prosecutor's office, they were not limited in time, scope, and they requested any and all communications between the township trustees and the prosecutor's office. The scope and breadth of these subpoenas far exceeded anything that would be contemplated to even be rationally related to her claims. The court correctly found that the communications and materials in the possession of the prosecutor's office were privileged. These documents and the information that the prosecutor office provides to the Board of Trustees for Litchfield Township are privileged communication. Plaintiff's appellant points to the letter issued by the Medina County Prosecutor's Office to the fiscal officer, from Assistant Prosecutor Shockley to the fiscal officer. I believe her name was Ms. Shaw, and claimed somehow, and this was the letter that said essentially that that Ms. Teodecki had apparently identified through these circulars that she had published in the community that she was the subject of the investigation and that there was no evidence of any wrongdoing, but she had waived any potential confidentiality and under the uncharged subject exception that the prosecutor's office indicated, and that therefore that document was free to be released. And that's, I believe, at the record on P89 is the record of it. That's the letter from Ms. Shockley, the prosecuting attorney, to the fiscal officer for the Litchfield Township. That essentially was a cover letter, but it wasn't communicated to the Board of Trustees. And it wasn't an attorney-client communication. And appellants try to make hay and try to say that that somehow waives the attorney-client communication, the fact that the prosecutor's office makes a statement to the fiscal officer, not even to the trustees, regarding an investigatory file. Your Honor.
Well, let me stop you there
yes,
for
Your
just
Honor.
a moment, because the appellant takes the position that the fact that his client references an investigation is really not the issue in terms of your waiver argument. It's the report, the releasing of the report, not the investigation, that is at issue, and that she did not waive the confidentiality of the matters in the report. How do you respond to that?
Your Honor, I think the appellant went a little farther than just to reference it something anonymously. She went in there and indicated that in her letter that the township had wasted money on the investigation, first of all, and that if the investigation had found something, they would have run to the DA and brought her up on charges. That's what she stated. And this is a report that, although it's disputed, had been mailed to Ms. Teodecki, although in her deposition she claims she never received that report. But I think Mr. McDermott stated in his deposition that he believes that Ms. Teodecki was given a copy of that report. So she goes far and beyond just alluding to that something had occurred. You know, she indicated in that letter that all of her credentials were in place, and that yes, my credentials were all cleared of any violations, but the trustees chose to keep me off duty. That was part of the report, went into her ability to keep some, much like a CLE for an attorney, but I think they're an EMT continuing education thing that she must have maintained, and there was some issue with the matter, with the manner and method in which she maintained those credentials, as well as issues regarding the dispute between her and the medical director for the EMT regarding the accreditation of some of these officers. So no, that letter circulated to the community and went beyond just alluding to something. She went into the weeds there as far as some of the details, and to say to kind of gloss over that would be a misstatement, Your Honor.
And she appears to take the position that it was her First Amendment right to make that statement, and that, as I understand the argument, that does not lessen the protections that she has. The exercise of her First Amendment rights do not lessen the protection that she has under the contract.
Well, if you assume that it's part and parcel of the contract, even though she admits it wasn't. But if you go that route, Your Honor, I think you must look at it this way. The public has a right to know where public monies are spent, and I think the public records exception allows that report to go out there. I mean, and to be published. But to say that you can do something under the First Amendment and throw darts at someone or at an entity or at the government, and at the same time, say the government's prohibited essentially setting forth what the facts they believe are, what its investigation calls for. Is just, she provoked the release of the report by having this one-sided circular. And I think Judge Marcus hit the nail on the head, that she was a public official, and that, that this was provoked by her actions, the release of the report, even though it was not bargained for or part of the contract between the parties.
We still have 2.5 minutes.
There was one issue raised in the brief regarding abusive process. We had a trustee who filed an Elections Commission complaint, who subsequently withdrew the complaint. This was a pro se individual who withdrew his complaint, and the plaintiff says, appellant says, because he withdrew his Elections Commission complaint, that somehow that was an abusive process. I think an abusive process, you would need to have something that was dismissed and then be refiled against someone. To use the system as a method to beat up on someone. That didn't happen here, Your Honor.
Well, what happened was that, at least from the briefs, was that the complaint was dismissed. The appellant consulted with legal counsel and showed up at a hearing.
Correct.
And was never advised that it had been withdrawn.
Correct. And
That's problematic.
well, if you have a pro se individual filing a complaint before the Election Commission, is it a problem? Potentially, but you know what? As any good attorney does when they practice, they check the docket before they go to court. It's been my habit for 25 years, Your Honor, to make sure that what's scheduled is on the docket and is going forward. And if there's some issue, if it's not there and I have it on my calendar, I'm gonna double check and see what's, that's.
So counsel would have been able to discern before making the trip that the matter had been withdrawn?
A simple phone call to the Elections Commission would have indicated that it would have been withdrawn. These types of proactive things that counsel normally would do and engage to alleviate those expenses to their clients are, what would have been, what would have resolved that issue, I think, without any additional or undue cost to the appellant. Thank you.
Thank you. And you have 5. You've only asked for 3, but you need 5.
Oh, thank you, Your Honor. First of all, the contract itself, as I stated, it's the issues brought forth were quote-unquote parole evidence issues as to what people believe the contract said, what was meant by the contract. The contract is the contract. There are 2 documents signed by both parties which include the confidentiality clause. Both documents refer to each other. So in the 4 corners of those documents, they had an agreement. There was consideration. Consideration was resignation. Consideration was staying on as a consultant. And consideration was confidentiality. And all of that was contained in the documents themselves. There was an issue with regard, we have one claim for defamation claim in the case against one of the trustees, Wargo. In that particular case, Ms. Wargo, at the time of the release of the report, issued a both written statement and read the statement orally to the public and produced the written statement to the local press. In that particular statement, Ms. Wargo said, there are charges against Ms. Teodecki. At that point, Ms. Wargo knew that there were never any charges against Ms. Teodecki. Based upon the fact that she used the word charges, she's basically accusing Ms. Teodecki of a crime, which is libel and slander per se. As I do not disagree that Ms. Teodecki is a public figure in this matter. However, actual malice breaks that barrier. What actual malice is saying something that's false with knowledge that it's false. Ms. Wargo admitted in deposition that she knew there were no charges against Ms. Teodecki.
So, with the appellees arguing that when she shared that information, she couched it in terms of allegedly, reportedly, how does that factor into your analysis?
I believe what she was saying, I believe, if I recall properly, she said Joyce knew there were charges against her, not allegedly or reportedly, in her document. Her document is part of the record. With regard to the issue of the preliminary breach by Ms. Teodecki on this matter, first of all, the record will show that the investigator originally did say that he provided this report to all the trustees and to Ms. Teodecki. He later corrected that because he was reading from a cover letter on top of his report that had CC'd all of these people. You will see later in the record that he recovered from that and said, no, I only provided it to the prosecutor, no one else actually saw it. Joyce could not actually preliminarily breach an agreement, one, because there's nothing in the four corners of that agreement that said that Ms. Teodecki had to keep her mouth shut and not criticize the trustees. There's nothing in that agreement. Two, she couldn't have because she didn't know what was in the report, so she could not have been saying issues that were coming directly from that report. She never knew that. Now, she could have been guessing at what was in the report, or when she said, if I did anything wrong, they would have charged me criminally for it. That's her opinion. Okay? And she has the right to give her opinion as to what goes on in Litchfield Township and what the trustees did. That did not have anything to do with them breaching the contract with Ms. Teodecki.
But wouldn't you agree that her comments really came across as challenging the trustees in a way that she knew or believed that they were bound and they could not respond, and she was basically commenting on the presumed silence? In other words, if they had something on me, they'd be all over it and they would be, doing this, when she knew that there was this confidentiality.
That's true, Your Honor. She did know that there was this agreement. However, one of the issues is that Ms. Teodecki let it be known by issuing that she was the target of this investigation. That was well known, a long time before the agreement was ever made. In other words, the people of Litchfield, because the press had picked up that they hired this investigator and that they were looking into Joyce Teodecki's activities for a number of months, that her responding to the fact that an investigation had occurred is all she did in releasing that open letter to the public. Yes, Your Honor.
And now you're up to time. I'm afraid I have to interrupt.
Thank you, Your Honor. We're asking that the judgment of the trial court granting summary judgment and the motions to quash be reversed. Thank you.
And we will take the matter under advisement and send you a copy of our opinions in the station. You may also find it on our webpage.
Thank you.
Thank you for your argument today. Have a good day.